How are you doing?
I don't think they do that. Germany's.
All rise. Humphreys County Chancery Court is now in session. The Honorable Judge David Wolf is present and presiding. All who have business can draw near and be heard. God bless the state and the United States and this honorable court. You may be seated.
All right, good morning. We'll start with a call of the docket. Call the first case, please.
2023 CV 155 regarding the conservatorship of Jared Crone.
Your Honor, that's my motion.
All right.
Good morning, Your Honor. Aaron Winters, Martin Miller, Cheatham, Shepherd, here on behalf of the conservator over the property only, Cumberland Trust. Cumberland Trust filed a notice of resignation last month. Also filed a petition to appoint a successor conservator, just accomplished service on all the interested parties, so it's ready to be set. Because Cumberland Trust will have to file an accounting within 120 days of their withdrawal, we're requesting a limited amount of time, additional time to file that to make Cumberland Trust that their final accounting matter.
All right. I don't know if there's any objection been filed, so we'll grant your extension. How much time are you requesting?
We didn't request a certain amount of time, Your Honor, because we're waiting on the petition to appoint successor. I would request more than 60. Is it possible to get 120 additional days?
Why don't we just reset this for a review on the first day of October at 10:30 a.m. Give you that much time to do what you need to do.
Is that October 1st, Your Honor?
October 1st at 10:30.
Thank you.
All right.
2026 CV 68 regarding Dorothy Stewart by Russell Stewart.
Mr. Ogle is running late, so we'll put it on the second call.
2019 CV 86 Alan Parker versus Megan Plant and Steve Plant.
Good morning, Your Honor.
Good morning.
That's actually three separate motions. One is the easy one is a motion to establish a special needs trust for Steve Plant by way of updates.
Are these folks behind you associated with this case?
On April 25th, the property, there was the remaining property in this partition actually got sold.
Oh, what is your name?
William Bell.
Okay.
These are some of the successors in interest to Megan Plant Vale, who died untimely last summer. They were substituted in along with Miss Vale's surviving minor children. Father over here is the appointed guardian ad litem for them, so we actually do have everybody in front of the court this morning. The property was sold at auction. That auction was approved by order on May 11th. All the sales have now closed. We are done with real property. All that's left is a common fund. Mr. Steve Plant is a disabled adult individual. He's institutionalized, has been for years now. It is reasonably anticipated that he either does or will need to qualify for various governmental benefits that are contingent upon his status of quotes resources, close quotes, as defined in the PALMS manual of the Social Security Administration. If he were to receive his share of the remaining common fund as eventually determined, it would likely disqualify him for that. And so we have filed a motion to establish a special needs trust, which will of course prevent those from being included in his resources for those purposes, subject to any legal requirement for reimbursement upon his death.
And what is your connection to this situation?
I got several papers from all the motions, and I had some things I wanted that were written down on the motions file that I wanted to address. For
Well, Your Honor, this is the special needs trust, of course, is not does not implicate either any of the other parties. It says necessary to get this done.
Special needs trust only only affects rather the individual that is
Correct.
Mr. Steve Plant, correct? And you have no connection with Steve. Wait a second. You don't have any connection to Steve Plant, correct?
correct, Your Honor.
All right. So your request is that a special needs trust be created to put the proceeds of anything that Mr. Steve Plant is receiving into the special needs trust.
Sheriff Davis, his cousin, is appointed conservator, and the way the trust is drafted, the conservator ex officio from time to time will be the trustee of this trust. And the conservators, because that will result in a constructive receipt by Mr. Plant of the money, which would sort of blow up the whole purpose of doing a special needs trust in the first place.
But with the fact that there is no other person to really be affected by this creation of the special needs trust, and that there is demonstrated a need, and I'm familiar with this case, so I'm familiar with the fact that there is a need, then I am going to grant your motion to create a special needs trust.
Thank you, Your Honor. The next motion, of course, now that the real property has been disposed of, and the entire common fund is in the possession of the clerk and master, this is actually the ending point at which the statutory claims of counsel to be paid from the common fund would logically end. Anything from this point forward would necessarily be in the nature of representing the individual interests of the parties rather than the collective interest of everybody in getting the property smoothly disposed of. With that in mind, I have presented my motion for the final approval of fees to be paid from the common fund as permitted by the statute. I understand Mr. Potter, similarly on behalf of the minor children, has also presented a similar motion, and we would suggest that that award would be timely and reasonable.
Right, I have reviewed both of your motions. Let me find out what these folks here are asking. Come up to the podium, please. And I'm sorry, but I'm going to ask you your name again.
William Bale.
William Vale. Okay. And Mr. Vale, what is your connection to this situation?
With the estate,
Yeah.
I was the husband of the widower of Megan Vale. I was my wife, passed away in July 25.
Okay. And what exactly are you here today asking?
I was there was 2 commercial properties, lots that were with the estate, and I know the court had ordered for Bill Collier to do the auction. They ordered everything to be sold the day of the auction. Those 2 properties were not in the auction. I've not seen anything about them being sold. And I know that Megan and I had hired Mr. Potter originally when this first started low, when I first got involved in it. And we fired him. We paid him somewhere around $15,000. And already I was wanting to know, I am not familiar with the law office very well, so I know the attorneys are wanting their money out of the estate now. That's coming off the top, is that gonna be for who they, the portion of who they represent, is gonna their portion of the inheritance? Or is it just coming out and then it gets split up between the state?
Mr. Let me, first of all, so your two things that you're asking is, one is the fact that you're saying there were two commercial properties that were to be sold, that you're saying they were not included in the sale.
Sir.
All right. And then the second thing is you're questioning whether or not the attorney's fees that were being paid to the attorney for Mr. Were you representing the estate? Is that correct?
Your Honor, we appear to have introduced a conceptual inconsistency here. There is no estate. This was a partition action. Megan Plant Vale was one of the parties defendant. She died. Her estate, by the way, has never been opened or administered. Now, later this summer, we'll hit the 1-year claims bar date on that. But when she died, we of course had to suggest her death and then to substitute in her known heirs at law. And we actually published on any unknown heirs and devisees. And then we substituted them in last fall. Now, Mr. Vale is partially correct. The court did order the main piece of property located on Dye Road to be sold at public auction. Done. In the same order, those two quotes commercial lots, they're actually landlocked. There's no public access. They're very rugged. They're unimproved. In the same order, and I've slept since then, Your Honor, but I'm pretty sure it was the November 11th, 2025 order directed that those be sold by negotiated sale by Mr. Will Sanders of Bill Collier Realty and Auction. That was done. A motion was presented to the court, which was also heard on May 11th, to approve the negotiated sales of those, and those negotiated sales were in fact approved and have been closed. So, when in fact those properties are now also disposed of, and their proceeds are also in the hands of the clerk and master.
And then the other, so commercial properties that you were questioning were not sold at auction, but they were instead sold by negotiated sale that was approved by the judge last month in May. And so those two properties have been sold. So the second question is where the funds that are being paid or requested by the attorneys are being paid out of the portion of the entirety of the estate, or not estate, but the entirety of the proceeds, or whether just on one portion of that. So Mr. Regent, you want to address that point?
Your Honor, the applicable statute provides that those fees are to be paid from the common fund, which necessarily includes all interests of all parties. And of course, the mathematical effect is that everybody ends up bearing a portion of those fees commensurate with his or her interest in the common fund.
Mr. Potter, you had stood for a second.
I mean, to the extent that Mr. Bell mentioned my name, I'll say that initially I did represent Megan Plant in a partition action that was filed by Alan Kent Parker, who is on the side of this case. He was represented by Mr. Bob Thomason, and we did negotiate a settlement to that partition action, which left the property in question being owned only by Megan and Steve Plant. This Plant and I terminated our relationship. I disagree about the way that happened, but time passed and she passed away. The court appointed me to be guardian ad litem for her minor children for purposes of this. There's no conflict. There never has been conflict. And I have reviewed the paperwork that has been approved by this board and the orders for the sale, and I think it's in the children's best interest.
The explanation that's been given to the court, I find to be satisfactory, paid by counsel in a partition action are to be paid from the common fund, and therefore that's the source of those attorney's fees that will be paid. Mr. Potter's role in the initial stages of that situation is completely different than his role as the guardian ad litem for the children. He was appointed by court order to act on behalf of the children. So his request for attorney's fees is a legitimate request that we normally will take place in a partition action or any other case where there is a guardian ad litem. So,
Okay, well, the reason I brought that up, Your Honor, is because the money that was paid to Potter after Megan fired him was, we had started the logging of some of the property, and Mr. Davis wasn't actually appointed conservator at the time, so the checks were being mailed to Megan and of the logging, and she cashed a couple of them to pay Potter because as soon as she fired him, he immediately immediately went after payment with threat of turning it over to collection agencies. So the money that came from the estate was paid to Potter.
well, all I can tell you is that as far as this court is concerned, those are two distinct and different situations, and therefore I cannot. We've given you the explanation for how that occurred, and it is a legitimate expense of the lawsuit and the common fund. So any issue you have regarding the payment that was made to Mr. Potter, that's not before the court in this situation. We're now just dealing with the disposition of these funds after the partition sale has occurred. So I appreciate you being here, but I think we've answered all of your questions.
Your Honor, there was a part of the motion was they said that the people that were renting the cabin that was part of the estate would be deducted from our portion of payment would be deducted from that. But I've seen no proof of where they paid. I'd like to be able to see physically where the renters paid the money over several years, not just the last few months where they paid the court. The account that was the money of the court and over the last, because they were there for years. And I know they lived there for years without paying.
When did you file your motion that you're referring to?
That motion was filed. I read the motion. I believe Regan filed the motion. It was in part of the motion that he filed about the.
I'm sorry, repeat that.
Money from the renters that were living in the
I
cabin.
know, but when did you file a motion?
I did not. I was motioning that he filed. I'm responding to that. He said that the money, half of the rent should be coming out of the.
So you haven't filed a motion?
No, I'm just responding to that motion.
Well, Your Honor, Mr. Vale, as a layman, is concerned, legitimately so, but he's actually getting a little bit ahead of the process here because the third motion that's before the court today is a motion to set this matter for final hearing to determine the interests of all parties. In the course of that hearing, proof will be offered. We'll be subpoenaing the tenants. Proof will be offered as to the matters that Mr. Vale addresses, and everything will be rehashed out. Mr. Vale mentioned money from the logging operations that was paid to Ms. Vale and somehow never got back into the court. That's actually been the subject of a prior order of the court to account for. And again, I'm going to have to beg the court's indulgence since I've slept since I last looked at it. But it was on the order of about $35,000 that Ms. Vale did not account for. But again, that's all. We've got a common fund. Every dollar is divisible by 100. And that is the point at which that hearing is the point at which all of these matters will come out in the wash.
And there's a motion to set.
Yes, sir.
And was it set at that motion for that motion to be heard? Has it been said? I guess.
Oh no, Your Honor. That's on the motion to set is on the court is on the docket for today as well.
All right, Mr. Bell. What we're going to do is we're going to set a hearing date, and that hearing date will entail what you're requesting to find out.
That's very good.
And Your Honor, I actually don't know about Mr. Potter, but I do have a proposed order on my fees.
All right.
I don't have one, Judge, but I can submit.
All right, if you'll submit your order.
Thank you.
When do we want to set this?
Would the court have any days in September or October?
Well, I'm back here in October. How long do you think it's going to take to try the case.
Half a day, Your Honor, maybe, probably less. I mean, most of the issues involved are matters
We've got stuff set
already
on
in
the
the record.
So we could do this thing.
second of October.
It works for me, Your Honor. 9 o'clock?
It works for me.
9 o'clock. All right.
Oh,
Now, Mr.
sure.
Bell, I'm going to suggest you might want to consult an attorney to make sure what your rights are and what you can and cannot do. If you're representing yourself, you haven't, you're not really necessarily a party to this action unless you have filed something. So you may be a part of the estate, but unless you're a named party, you don't get to participate in the hearing. You understand that?
Your Honor, they, Mr. Vale and Ms. Wakefish, and of course the minors were actually formally substituted for this plan. It's just style.
It has been substituted. Well, I haven't touched this file in quite some time. So, all right, then we'll see you here October the 2nd.
2026 CV 54 Kendra Killebrew versus Philip Killebrew.
Since that's my case, I expect that about 45 minutes. That'll probably take
Well, it's a hearing on a petition. Are you involved in that?
Mr. Killebrew.
Let me run through the rest of these and see what we've got. So.
2026 CV 62 Casey Show versus Mark Dozier.
So we have service yet. Mr. Dozier, I mean, Michelle, we still do not have service on Mr. Dozier. So I'm going to have to reset this case. It will remain in full force and effect until he's served, and you'll just have to be notified.
Can I ask why it's taking so long? I
I
found this
have
on the
no idea.
11th.
It would be up to the sheriff to find him and locate him. If you have information as to where they can
I've
find
given
him.
him his
Pardon?
address, his phone number, everything of where he's at. It was listed in the
then
paper.
contact the sheriff's department today and let them know and remind them that you've given them that information.
Yeah, because it's childcare that I'm out every week and I have to come
All
up. All right, I appreciate you. Thank you.
2026 CV 69 Paula Ayers versus Scott Gregory.
No service. As we do not have show that the defendant has been served with this ex parte order of protection. So they are still going to try to serve him, and this will stay in effect until they can get him served. But they'll let you know when they have him served and when you can come back to court, okay?
Okay, does that mean you can still come back to my house?
I'm sorry?
Does that mean you can still come back to my house?
He's not supposed to. You need to contact the sheriff's department if he were to come back because they're looking for him to serve him. Okay? All right. Thank you. Could you move that microphone back towards the center, please?
2026 CV 72 or 71 Alicia Hall versus Darnika Hilsman.
Any service? Ms. Hall, again, we don't have service on Mr. Hilsman at this point in time, so we can't proceed. The ex parte order will remain in full force and effect until he's served. If you find out where he is, you can contact the sheriff's office and let them know, and they'll get him served, okay?
Do you know when the next court date is? So I can let by.
They'll have to let you know. We don't set a court date until he's served, okay? All right, thank you.
2026 CV 72 Ashley Curtis versus James Mallard.
Good morning, Your Honor.
Good morning. Mr. Mallard, there's been a notice sent to the clerk that you have consulted with Ms. Roberts as your attorney.
Yes.
Is your desire, first of all, Ms. Curtis, this is the hearing today to determine whether or not there should be an extension of any order of protection or whether an order of protection should be sent. I think actually should be entered. At this point, the there was no ex parte order that was entered, and instead it was set for a hearing. Do you still desire to obtain an ex parte or an order of protection?
I do. My attorney, we won't meet until the 15th. She
Okay.
advised me like how
So
she-
you're going to have an attorney represent you, and you have talked with Ms. Roberts about representing you. And I'm going to reset this matter. Let's set it for next month. You're meeting with them the 15th of July. Okay.
July 22nd.
About July 27th. All right. Until that time, there's no order of protection been entered, but Mr. Mallard, you can rely on your attorney to give you advice. There needs to be peace between the two of you. I've read through the affidavit, and it sounds like to me that this is a situation that could be remedied without having to go through a hearing, but I want your lawyers to be involved. Okay. All right. Thank you.
Thank you.
And Mr. Odom is here.
2026 CV 68 and regarding Dorothy Stewart by Russell Stewart.
Your Honor, this is a action for a conservatorship that I filed for Miss Dorothy Stewart. This is my client, Mr. Russell Stewart. Of course, that was a sworn petition. Mr. Odom was appointed as the guardian ad litem for Miss Stewart. And I believe he's met with her and let him speak to that part.
Judge, I was out of town, out of state on vacation last week, so I met with Miss Stewart on Saturday, this past Saturday. She's living in Blakeford Rehab at Burton Hills, near Green Hills. Very nice facility. When I arrived, she was in her room meeting with her daughter. Her daughter, Lisa Marshall, was there. I believe Miss Marshall was in the courtroom today. Based upon my conversation with her, it's clear that she is probably under a disability and in need of a conservatorship. She did express to me opposition to the proposed conservator, but didn't really articulate any specific reason except that there was sort of an absence of contact. Said, you know, maybe he was mean to her, ignored her, things of that nature. But as I understand it, Ms. Stewart was in a long-term relationship, had a partner that she lived with for 30 years. And there was some event, something happened with the family after he passed away. I don't think that she knows that he passed away, to be honest. And I think some of the family was coming in and getting some of his property that may have been her property too, and there was a falling out among the family. So she did not articulate to me that she wanted an attorney appointed. She did not articulate to me that she wanted to be present for a hearing. She did not tell me that she was opposed to a conservatorship, that she probably needed assistance and someone to serve in that capacity. She did express to me opposition to Mr. Russell Stewart serving. So it's my opinion that the conservatorship is in her best interest. I think there needs to be some further investigation during the pendency of the temporary to determine who should serve in that capacity.
Your Honor, Mr. Russell Stewart is the ward's guardian, power of attorney. She previously appointed him to serve in that role. And from a statutory standpoint, he does have a superior standing to be appointed as conservator. We are happy for this to be a temporary conservatorship and let Mr. Odom meet with my client and investigate further. But the need for this is immediate because this rehabilitation facility is getting close to ready to discharge Ms. Stewart, and she's not able to go back to her home, which is what she is
kind of threatened to do, which is where the tension comes with my client telling her, Mom, you cannot go back home, that you've got to go somewhere else. And
Well, Mr. Russell Stewart, if you'll raise your right hand, let the clerk place you on the roll.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right. Ms. Knowles, if you want to throw in some proof to allow me to at least enter a temporary order, I'll do so.
yes, Judge, if you'll go. Do
You
you
can
want
just do it from there.
will you please state your full name for the court?
Russell Wade Stewart.
And Mr. Stewart, how are you kin to Miss Dorothy A. Stewart?
I am her son.
And does Miss Dorothy Stewart have a power of attorney currently?
She does.
Is that you?
That is me for 10 years.
So you served in that role as 10 years. Do you have any felony convictions?
Absolutely.
Okay. Do you understand that if the court appoints you temporary conservator, you'll be responsible for management of your mother's finances and her health care?
I understand completely.
Do you believe your mother is competent?
I do not.
Do you believe it's a danger for her to return home and try to manage her own financial and health care?
I do believe.
Are you asking the court to appoint a temporary conservator for Miss Dorothy A. Stewart?
Yes, I am asking for that conservatorship.
Now, Miss Stewart's finances, how much money is in her bank?
Around $4,000.
And that is the total of her liquid assets. So you're asking the court to waive the bond at this time as it does not exceed $10,000. And outside of miscellaneous personal property, are you aware of anything else she owns?
There was a 20-plus-year-old pickup truck that belonged to her, belonged to her and her partner, deceased. She cannot drive. Been sitting in the driveway since his passing. That's the only asset of that's personal belongings, such as jewelry.
Does she own any land?
Or
Does she own any land?
she does not, sir.
All right, I'm going to appoint Mr. Stewart as the temporary, I'm going to make it a temporary conservatorship. And just out of an abundance of caution to allow Mr. Odell or anyone else that wants to be heard on it at a later date. But certainly she needs to have someone acting in her behalf right now. And Mr. Stewart, having been her designated power of attorney, he is the most logical person to serve in that. I find no reason at this point why he should not be allowed to serve. And we'll set it for a review. Give me about 90 days down the road.
We could do October 1st at 10:30.
October 1st at 10:30. For just for a review to see if there's any issues.
I'm sorry, Judge, I was getting something right on. What was that date?
October 1st.
October 1st at
At
10:30. That's my circuit civil docket call at 9, followed by Chancery at 10:30.
Yes, sir.
All right. Stewart, you'll be serving on as your mother's conservator until that time, and we'll look at it and see if there's any issues. So, all right. Thank you.
Thank you, Judge.
All right, does that leave us with Killebrew? All right, Killebrew versus Killebrew. I'm going to take a short recess. I need to meet with General Allen for a moment before we start.
We're talking
You all talking about
All right.
short recess.
How are you? Do you know that I did letters on the survey?
Yeah.
You did
Yeah.
letters just like.
Yeah, just like normal, I just do
Okay.
temporary.
All right.
Yeah.
And over here, do I do those or do you do? Okay.
Yes.
So when would I send him back up here to sign up here in a few days?
It won't take long, because what I usually just We have a form now where we just adopt this, so we don't have to type up everything, we just certify the copy of the order, and that way we don't mess anything
Yeah,
up,
that's
you know?
smart.
So that way it shouldn't take long if they wanna wait
Okay,
around.
well, I'm gonna catch you then.
Okay.
Mr. Potter and Mr. Baker, just let me know, I'll be in the office, let me know when you're ready. Thank you. Well, that's what I usually do, but the whole thing is. Okay, what's your? We're all the same.
on second thing, let's go outside. Take our votes.
You guys say.
Yes.
And they stand right there where I thought, and I know that we said. I got so
It's the first 1 year, so I don't think I've ever figured it out. Mr. Gilbert.
All rise.
Hey, Stewart.
Would you let our clerk know we're back? Sorry, I should have stuck my head in and let you know. All right, I think we're ready. My understanding is in Killebrew versus Killebrew that we have an announcement to make.
We do, Judge. In this case, and the Kilbrews are here. There's a divorce filed in 2026 CB 55, and there's also a no contact order out of a criminal case that's pending. We've agreed between the council and the parties, we've talked to them about this. We're going to maintain the OP, the no contact order. We'd like to transfer that in the jurisdiction to the 2026 CB 55. We have another hearing, I think, on the 10th of July in this case, so if we can just maintain this.
You really want to just consolidate the order of protection with the divorce action?
I do. Yes, Judge, there's a criminal case against Mr. Killebrew. We had a preliminary hearing downstairs probably 2 weeks ago that was bound over against criminal numbers county grand jury. And Mrs. Killebrew is filed for a divorce. Hillary Dickson obviously representing Mr. Killebrew in that. So I think the agreement between the parties is that we will transfer this to the divorce court. We'll just leave a no contact in place for the divorce court.
Right. Then we'll just simply order that the order of protection be consolidated with the divorce action and set for hearing, which is set for hearing July what?
10th or 11th. 10th.
We'll consolidate it and set it for hearing on that same
I
day.
think there's 10 day, and then like the motion set on that.
Right. And then we'll put an order down to that effect and maintain the order of protection until the hearing in that case.
Maintaining the ex parte.
Correct.
Sounds good, Judge.
All right, thank you. Well, the old saying is I'd rather be lucky than good, so. That concludes our business for today, so we stand.
All rise. All